Good morning, everyone who's joined us. I think we're just about reaching critical mass. So Miles, I'll ask you to take it away.
Okay, great. Thank you, Jim, for orchestrating all of this. And thank you to everybody who's tuned in this morning. I apologize for those who were listening in a few minutes ago. My internet connection appears to be weak this morning. I guess too many neighbors watching Netflix. And so I'm going to do this by audio only today. We're very grateful to Parsons, Behle for their part, and Latimer for their partnership in pulling these webinars together. We did one last week on force majeure, acts of God, and contracts, and received tremendous positive feedback after that. We're grateful that they joined us this Friday. And Jason, we hope to potentially do this every Friday. We can make it Friday mornings with Parsons, Behle, and Latimer. But today we're going to be talking about a very important topic. Before we jump into that, I just thought I would share with those who are joining our webinar series for the first time a little bit about what World Trade Center Utah is doing as we all face this unprecedented challenge. You know, World Trade Center Utah exists to help companies grow and expand their sales internationally, to attract investment here to the state of Utah. And then as we're doing that, we're really leading out to enhance Utah's global brand. Here in this current period of time, we're all under pressure. This is a significant challenge for Utah businesses. And so we are recalibrating our programming and our services to make sure that we're able to plug in and support Utah businesses as we all face this significant challenge. And so what we've done is we've taken our normal programs, like our grant programs, the free consultations and market research that we do, the business-to-business matchmaking, and we're working to surge those to make sure that any Utah company, as they face challenges internationally, that we have the grant resources available to help with cash flow right now, to help de-risk things. If you go to our website, you can learn more information about our grant programs. We also have a global network. And so we are typically able, in just about any country, in any industry, able to connect Utah businesses with the people they need to connect with. In good times, we're focused on increasing international sales. Right now, we're focused on retaining sales, doing everything we can to help companies minimize the extent to which they need to retreat from global markets. And that is a couple things for us. One, it helps with cash flow and sales right now. And two, it's critical because the extent to which we can keep our companies in global markets, a lot of other companies in other parts of the world and other states are pulling back significantly. As we bounce out of this and enter into a stabilization recovery phase, the extent to which we can keep our companies present in other markets, it'll create significant market opportunity. And so the extent to which we're able to minimize the economic dip now, we will be accelerating global growth for Utah businesses as we come out of this. And so we're very focused on, again, these grants, consultations, market research, and this matchmaking. So if you've got problems internationally, if you need to find a new distributor, a new manufacturer, you're uncertain about how the rules of the game are changing in any particular country, please reach out to us. We'd love to have you plug in and partner with us and allow us to help you as you navigate these difficult times. One area where we are also focused is to make sure that companies have the expertise that they need in order to respond to all the changes we see, both with laws and regulations and stimulus packages. So they have good business insights and intelligence so that you don't have to spend time digging around the internet or elsewhere to try to get answers to questions, but you can get these answers, get the information you need so you can focus on your business and moving forward. And that's what we've been doing through our webinar series. And so this is, I'm losing count now, our fourth or our fifth webinar in the past week. We're doing this one right now. We will do another one with the Small Business Administration at 11:30 this morning. We're planning several others for next week. So please, if you're not on our distribution list, go to worldtradecenterutah.com, WTCutah.com. There you can sign up to receive our emails and to make sure that you are in the loop on all the webinars that we're doing. And so with that, again, we're very grateful with Parsons, Behle, and Latimer for being with us this morning. Jason Castor does a tremendous job doing community outreach and making sure that they are plugged into the community and that they are sharing their expertise far and wide. Jason, I'll pass it over to you and let you take this and run with it with you and your team.
Great, Miles. Thank you very much. We really appreciate the opportunity to partner with World Trade Center Utah, with you, your fantastic team. And thanks again for the great work that World Trade Center Utah is doing for our community. just as a normal course of business, but certainly during this really difficult time. As Miles mentioned, my name is Jason Castor, and I'm the Director of Business Development for the law firm of Parsons, Behle, and Latimer, and we're thrilled to have all of you join us this morning. We've got a lot of content to get through today, so I'm going to jump right in with just a couple of housekeeping and introductory elements, and then turn the time over to our speaker. Today's webinar will focus on essentially 3 separate acts. We are going to be talking about the Coronavirus Relief and Economic Securities Act, also known as the CARES Act. The House passed this on Wednesday. We expect that it will be passed, the Senate passed it on Wednesday, and we expect that it will be passed by the House today and signed into law by President Trump at some point today. We are going to give you a primer on some of the elements included in the CARES Act. We will also be addressing the Families First Coronavirus Response Act, and lastly, we will be touching on the WARN Act. So a lot of content to get through. Our format for today's webinar, as you all are aware, if you participated in a prior World Trade Center webinar to date, all the lines will be muted, but we will be taking questions through the chat function. So please, as we move through this slide deck and presentation today, submit your questions using the chat function, and we will do our best to respond to those questions. This webinar will be recorded and put on World Trade Center Utah's website, along with its YouTube channel. And of course, at the conclusion of today's presentation, we will share all of the slides with you. Our presenters today include my tremendous colleagues who have been working tirelessly to stay on top of all of the legal issues associated with COVID-19. Ross Keogh, Mark Wagner, Sean Monson, Susan Mott-Cheadler, and Christina Jepson will be presenting today. And again, I can't thank them enough for their leadership and for their willingness to really rally around everything that's happening during this really difficult time, and devoting the time, the energy, and resources to ensure that all of you have information that is timely and relevant. So again, thanks to our presenters for making this happen. One other note that we just have to touch on, today's presentation is for informational purposes only and should not be construed as legal advice. You should, if you have specific questions or specific issues that need to be addressed, you should consult with legal counsel. And with that, I am going to turn the baton, or hand the baton, over to Ross Keogh. Ross is going to talk about the fundamentals of the CARES Act and loan forgiveness that is included in the bill. Ross?
Thank you, Jason. Just making sure I'm coming across for everybody here. And I'm not seeing the video popping up on the side, Jason. So,
Ross, I can hear you just fine, so you should be
awesome.
Good to go.
Great, thank you. Well, as I'm sure we're all dealing with right now, and I have been on the phone with countless clients over the last 24 hours, really trying to understand what's next for the American economy and their business. And to just put this in perspective, the week ending March 21st, we had 3.28 million claims of unemployment in this country. We're dealing with a workforce of only about 162 million people. And I think the consensus view is that another 3 million or 4 million people are filing for unemployment this week and trying to get access to those benefits. So easily 10% of the American workforce is being laid off or displaced as a result of this act. The good news is Congress has acted. They have, with what is being referred to as the CARES Act, and don't remember where or how the acronym originated on last Friday when the bill was originally introduced, put together a table. And that table has 4 legs. The first leg that is contained in that legislation is a $500 billion in appropriations that will facilitate bilateral investments in large firms. This looks a lot like TARP, but has a different sort of overview and management oversight type of program. We're not going to talk about that today. The other leg of the table is $349 billion that will be dispatched, we understand, through local financial institutions to directly support small firms and individuals. This is to maintain and stabilize existing workforces and for our business clients and businesses across the United States. We will talk about that in more detail shortly. The next leg of that table is the direct unemployment benefits and taxpayer payments that will be taking place under the legislation. Mark Wagner is going to cover those unemployment benefits in more detail. And just to give you a preview about what you as an individual taxpayer may be receiving, the bill calls for a $1,200 payment made to each individual and a $500 credit per child. That caps out on, I believe, 2018 taxable income at $75,000 per individual and $150,000 per married family. The fourth leg of this table, of this $2 trillion table that Congress has put together, is a multitude of other spending and support provisions that are going to be distributed, whether to states and local governments or hospitals, or help to prop up programs such as Social Security and unemployment. So with that, we'll go to the next slide and provide a preview of what that $349 billion, that Paycheck Protection Program means. So what Congress has done is they've taken the existing SBA 7A loan program and they've significantly expanded it. If you are a business with less than 500 employees that was operating before February 15th, 2020, you are eligible for a loan from an SBA lender to stabilize your business. The eligibility has been expanded significantly. It now includes nonprofits, only C3s, it includes tribally owned businesses, and also appears self-employed individuals and independent contractors, i.e. your Uber driver will be able to get benefits under the program. There's no personal guarantee that's required, and there are also extensive deferral and forgiveness provisions, which I'll discuss in more detail on a following slide. Rates are capped at 4% interest, and they will generally have a 10-year amortization. The amount of the loan cannot exceed $10 million. Your loan amount is a function of your monthly payroll. You take the average of the last year on the date of the loan, and you multiply that average monthly payroll by 2.5. If you have 10 people, you're paying them each $2,500 a month, your loan amount would be $25,000. If you have employees who receive annual compensation in excess of $100,000, you need to trim, for the calculation purposes, that compensation to $100,000. It's our understanding that these loans are going to be limited, and so those that are first in line working with their SBA lenders, who will have discretion over who gets the loans, will be the ones that receive them. There are provisions that provide for a deferral of up to 6 months of the interest and principal obligation, and there also may be interest subsidies that are available to certain employers who are directly impacted by COVID-19. The forgiveness piece is the biggest part of the carrot. Under the forgiveness program, if you are able to generally stabilize your workforce for the next 8 weeks, the SBA and your SBA lender may be able to forgive the entire principal amount of the loan. To qualify forgiveness, you must spend the loan proceeds on payroll costs. You can spend them on interest of any covered mortgage obligations, rent obligation, and utilities if you committed to those contractual obligations before February 15th, 2020. And only the amount that's spent during the 8 weeks following origination is eligible for forgiveness. But since this is a function of payroll, and since you have 2.5 multiple, it's generally, if you're able to maintain a group of people who are making less than 100,000, you're going to qualify most of the income for the forgiveness. To the extent that you're not able to maintain your entire workforce, there is a proportionality requirement or reduction for the way that the forgiveness is going to be applied. So if you do end up having to lay people off, forgiveness is still on the table. It's just going to be proportionally reduced. You also are allowed to make reductions in the gross or in the net amount of pay that you make to people up to 25% and still qualify for the complete amount of forgiveness. To the extent that you have previously made layoffs to respond to the crisis, you can bring those people back on your workforce, rehire them within a window, and they will be part of the calculation towards forgiveness. It's important to note that there's no cancellation of debt income and that they're associated with this forgiveness, and that the lender has some discretion to grant and will require a lot of certifications as to how the proceeds were used and that you met the requirements for forgiveness. I have been in communication with SBA lenders this morning on behalf of clients, and they are starting to put together and understand how this process is going to roll out. I strongly suggest that if you're eligible for this loan, that you reach out to an SBA lender. We understand that the money is going to come through the SBA lenders directly, not to come through the SBA like maybe the emergency loan assistance, and that they will be in a position to process your application. They need information. In particular, they're going to need payroll information so they can calculate your eligible loan amount, your organizational documents, obviously tax returns, and any other sort of general loan information you expect to have. The final thing I want to talk about is a number of other additional tax provisions, stepping aside from the SBA provision, that are included in the bill. When you're thinking about an SBA loan, many of these are in lieu of an SBA loan, and so it's worth knowing that these are also on the table. First, required minimum distributions from IRAs can now be suspended. The second tax provision that may be of interest to an employer is you can now cover up to $5,250 of student loan interest on employees' tax, and this can be tax-free. So you can make a direct payment to your employees to help with their student loans and then take a tax credit and not have to include that as compensation to the employee. There's also a refundable payroll tax credit for employers that have to face either a closure, such as a stay-in-place order, or they've seen a 50% decline in gross receipts. If you have had those exogenous issues take place and you yet are able to retain people, whether they be key managers, you can get a 50% credit for their payroll costs. Note that this is in lieu of the SBA loan. So sort of two different paths to payroll stabilization. And for some businesses, this might be a better, quicker, easier option, especially if they have a sufficient existing liquidity and maybe have made some very significant workforce reductions and won't qualify for the forgiveness. The other immediate change, which may affect your existing filing and cause you to work with your CPA, is that net operating losses can now be carried back 5 years, and this starts in 2018. So if you need liquidity, you can amend past returns, carry back net operating losses, and then look to Treasury to cut a check. If you're a C corporation, this provision will be of particular interest because it appears that you can carry back to the higher pre-Tax Cut and Jobs Act rate of 35% and apply net operating losses against that rate. That may be something that Treasury issues guidance on to clarify whether that was the intent of the legislation. The other significant change is that starting in the 2018 tax year, so again, amended returns are on the table, you'll be able to immediately depreciate improvements to the interior portion of a commercial building. And then the other significant tax credit on the payroll stabilization side that's provided in the bill is that you can delay paying the employer side of Social Security 6.2%. 50% of that can be delayed until December 31st, 2021, and the second 50% of that till December 31st, 2022. This is in lieu of just the SBA loan forgiveness. So this is applicable if you take an SBA loan, but don't then go and ask for the forgiveness piece. Obviously, we still don't have a final bill. There's the potential that pieces may change, but this legislation has immediate impact on my clients, and I strongly urge you to try to take advantage of the SBA provisions. And with that, let me turn it over to Mark to talk about the unemployment provisions.
Ross, thank you very much. As Ross indicated, we're now going to turn the time over to Mark Wagner, and Mark is going to address provisions under the CARES Act related to unemployment insurance. Mark, I'll turn it over to you.
Thanks, Jason and Ross. There are some pretty dramatic unemployment provisions in the CARES Act as it's currently formulated. Generally, what this does, generally the system contemplates state and federal/state agreements, individual to each state, to essentially funnel money to individuals who are affected. First way in which it does this, it's dramatically different from most unemployment schemes, is that this will cover individuals who are self-employed and or gig economy workers that are adversely affected by this entire COVID-19 pandemic issue that we're dealing with. If they're otherwise not covered by their state's unemployment compensation laws, or if they've exhausted their state unemployment compensation benefits as of that time. If they're covered by the provisions in the CARE Act, then the self-employed individual or gig economy worker will receive essentially the same unemployment compensation benefits as regular employees would receive under the relevant state's workers' comp law. Then for individuals employed by traditional employers, third parties, this also will allow for expanded unemployment benefits in several ways. And again, one thing to notice, because these are contemplated to happen through federal and state agreements, benefits under either portion won't begin until those agreements are entered into, but I expect a fairly expedited process for the federal state agreements to happen. And then, so again, as to traditional third-party employees and employed by third-party businesses, some changes that expand this. One is that the traditional first week waiting period would be eliminated, with the federal government funding unemployment benefits for that. One of the most dramatic provisions is that federal payments referred to in the statute as federal, or the bill at least right now, federal pandemic unemployment compensation payments. These are going to be $600 payments in addition to what a worker would otherwise be entitled to under the state's Unemployment Compensation Act. These are going to, so how that works, they're not going to be prorated. It's not dependent on the level that the person is receiving benefits on. So if you have an individual, a former employee, or if you yourself are in that boat, you're receiving the maximum compensation allowed under the state act, you'll get a $600 payment, or that individual will get a $600 payment. If you're receiving only a portion of what's available under the state Unemployment Compensation Act, because your income level or your work history doesn't justify a higher level, you'll receive the state portion plus the $600 payment. So it can actually operate in some instances for some lower income individuals where they may actually end up earning more or receiving more under the unemployment benefits provisions than they did while they were employed. That's something that is contrary to most schemes, and it's kind of contrary to the intuition or gut reaction. But the fact that that's the case is fairly clear from the fact that there was at least one senator during the bill's debate that had proposed an amendment to alter that very effect, and that amendment was soundly rejected. So that's fairly dramatic. Now, it is limited in time. This portion, it's up to 4 months of these particular provisions, or these particular payments. The up to 4 months means they end July 31st of 2020. And so that means that if the state and federal government enter into an agreement right away, up through that date, you'll have those, through that July 31st date, you'll have the payments. But they'll be limited in time until that. The federal unemployment provisions also provide for an additional 13 weeks of unemployment compensation benefits at the applicable state levels. These end earlier at the end of the additional 13 weeks, or December 31st of 2020. The payment of these benefits are generally applicable to, subject to generally applicable rules on actively seeking work, replacement work, etc. there are some exceptions for the last category in ways in which the federal benefits expand existing unemployment compensation, and that is that there are 27 states currently that have short-term compensation programs that provide essentially for the equivalent of prorated unemployment compensation for people who are still employed, but have a reduction in hours. And the CARES Act contemplates federal funding of these types of programs and would allow states to enact similar, who don't have them currently, to enact similar programs and receive benefits under those programs. Depending on the type of program adopted or enacted by a state, it might be fully funded by the federal government, or it might be 50% funded by the federal government and the and 50% by the applicable employer, who would be paying for half of the prorated unemployment compensation for reduction in hours. This short-term compensation arrangements are capped at they're capped at an amount equal to the employee's regular state unemployment benefits for a period of 26 weeks. With that, I'm going to turn my time over to whoever we have next. Sorry.
Hey, thank you, Mark. The next segment of our presentation today is going to focus on amendments to the Families First Coronavirus Response Act. And I'll turn the time over to Sean Monson, who's going to discuss FMLA amendments. Sean?
All right, thanks, Jason. So as Jason said, last week on Wednesday, the Congress passed and President Trump signed the Families First Coronavirus Response Act. And I'm just going to refer to that as a Response Act. And what that statute did is it did two things. It amended the Family Medical Leave Act to provide for certain additional leave rights that are in addition to what already is existing under the Family Medical Leave Act. And it also created some sick leave benefits. I'm going to talk about the amendments to the Family Medical Leave Act. Susan Machiter is going to talk about the sick leave benefits. So just kind of a way of a background, I just want to spend a few minutes talking about what the act did, and then I want to spend just a couple minutes addressing some of the most common questions we've been getting since this statute was passed. So if you think about the Family Medical Leave Act, that statute's been around for a long time, and it provides for leave for employees under certain conditions. And that leave is unpaid. It's 12 weeks of unpaid leave for the birth or adoption of a child, for a serious health condition of the employee, for the serious health condition of a family member. Those are the triggers for what we would call regular Family and Medical Leave Act leave. This statute amended it for a very, very limited purpose. And that purpose was to allow people to take leave if they have to take care of a child because that child's school has been closed or because the child's daycare provider is no longer available. So it amends the FMLA to provide for leave in those limited circumstances. The rest of the FMLA stays the same. It's just this adds another trigger. But with this trigger, there are some additional, this trigger for this leave, it's a little bit different than the regular FMLA leave. And there are a number of differences that we'll just highlight real quickly. The first difference is the employers who are covered. Under the regular FMLA, employers must have 50 or more employees within a 75-mile radius. Under this new amendment, what we'll call COVID-19 FMLA leave, employers who have fewer than 500 employees are all covered. And so if you have one employee as an employer, you are covered. If you have 5 employees, you are covered. Now, The Secretary of Labor is going to be issuing regulations that will potentially exempt 50 or employers with 50 or fewer employees from these requirements. We have not seen those yet or what they're going to look like. I would imagine, we think they're going to be coming out before April 1st when the act goes into effect, but we don't know for sure. Maybe they might come out before then. Another difference between the regular FMLA and COVID-19 FMLA leave is that an eligible employee under the regular FMLA had to have worked for a year with the employer and worked for 1,250 hours. For COVID-19 leave, the employee only has to have worked for 30 days with the employer. There also is an exception, potential exception for employees who are healthcare providers and first responders. All right, can we go to the next slide? All right, and this next slide kind of highlights what the biggest concern that employers have. For regular FMLA leave, the leave is unpaid. The employee is entitled to 12 weeks of unpaid leave. For COVID-19 FMLA leave, the employee is entitled to 10 days of unpaid leave. And then after that, from day 11 to the end of a 12-week period, the employee is entitled to 2/3 of their regular rate of pay. That's based on the number of hours the employee would normally be scheduled to work. If the employee's hours vary from week to week, it's based on a prior 6-month average. The leave is capped at $200 a day or $10,000 in the aggregate per employee. And Susan's probably going to talk about this, but this cap also works in conjunction with the sick leave benefit, because under the sick leave benefit, you can also you can get 2 weeks of paid leave for this same triggering event, and that is to have to care for a child whose school is closed or whose daycare provider is no longer available. And so the maximum amount you can get under the statute is $12,000 if you have to stay home to care for a child because the child's school has been closed or because the child's child care provider is no longer available. One other pretty significant difference is under the regular FMLA, you can require an employee to take accrued but unused PTO during the leave period. For COVID-19 leave, that it's up to the employee whether they're going to take their PTO during any part of the leave period, but they can't be forced to do so by the employer. So again, this statute amends the FMLA for a limited circumstance of allowing folks to have leave if they have to take care of a child because that child's school has been closed or because that child's daycare provider is no longer available. That's the only way that it amends the FMLA. It doesn't change the FMLA in terms of, people are asking, well, does that mean that all FMLA leave is paid? No, it doesn't. It only changes it for this limited trigger of having to care for a child whose school is closed. So a few of the questions we've been getting that I just wanted to touch briefly on. One of the biggest questions we've had after this bill was passed was, what about intermittent leave? And we have some guidance. We don't necessarily have regulations. We have some guidance from the Department of Labor that intermittent leave will be allowed and in fact is encouraged. The Department of Labor says that employers and employees should work collaboratively to see if there's a solution for intermittent leave for this type of, if the employee has to take care of their child because the child's home from school, they could work out an intermittent leave schedule where the work schedule of the employee might be changed so that they can take care of their child for certain hours and then go to work at later hours and someone else can take care of the child. So that is something that is a possibility and that is encouraged by the Department of Labor. One of the biggest concerns or questions we've had from employers is when this act was first passed, is employers were feeling like it was forcing them to make a decision that they had to either lay off their employees or be potentially subject to these benefits. The guidance issued by the Department of Labor clarifies that if the employer's workplace is closed before the act goes into effect, before April, and the act goes into effect on April 1st, 2020, and it ends on December 31st, 2020. If the employer shuts its place of business before April 1st, then the employee doesn't have any leave rights under this amendment. Likewise, even after April 1st, if the employer shuts its place of business because of either they don't have any business or because of a federal or state or local directive, then the leave rights, the employees do not have leave rights. And that's even if they've requested the leave before the employer shut down. So we've got April 1st, an employee requests leave on April 2nd. On April 3rd, there's a shutdown. Those leave rights end as of April 3rd. And even if the employee is actually on the leave, period. So April 1st comes around, the statute goes into effect. The employee goes on leave on April 2nd and is on leave through April 5th. On April 6th, there's either a directive that the employer has to close its doors, or the business is so bad that the employer has to shut down. The employee's leave rights end as of the date of the closure. A couple other questions that people have had is, what about if they're on furlough? Furlough is treated the same as though the business was closed. Essentially, if employees are put on furlough because there's no work available for them, then the leave right, they don't have leave rights under the statute. So with that, I will turn the time over to Susan to talk about the paid sick leave benefits.
Hey, thanks, Sean. The paid leave under this, can everyone else mute their line real quick? The paid sick leave is a little bit simpler than the FMLA leave rights because it doesn't modify an existing statutory scheme that everyone's familiar with. It just it provides an entirely new benefit for employees. And it also, like the FMLA changes, applies to employees with 500 or fewer employees. It begins April 1st and it ends December 31st. So this is not something absent further action by Congress that will carry over into the new year as a employee benefit or entitlement. Like the FMLA leave provision, the Department of Labor has been given explicit authority to exempt businesses with fewer than 50 employees if the sick leave benefits would jeopardize the viability of the business as a going concern. It's unclear right now what types of evidence the employer would have to provide to establish that. And if they don't exempt them automatically. It also provides that healthcare providers and emergency responders can be exempted from the definition of employers under the Response Act. And if the Department of Labor decides not to exempt those automatically, it allows the individual employers to opt out at their own behest. Next slide. So in terms of eligibility, full and part-time employees are eligible. And so that includes people that as part-time employees might not otherwise have any benefits. And that is a fairly substantial difference. It applies to full and part-time employees if they're unable to work, including telework, because they themselves are in a federal, state, or local quarantine order. They have been advised by a healthcare provider to self-quarantine, or they're experiencing symptoms of COVID-19. That quarantine order, as Sean mentioned, does not include shelter-in-place orders from municipalities or states or counties. So employees who can't work for that reason are going to have to use unemployment insurance instead of relying on employer-provided sick leave. It also covers somebody who is caring for somebody who is on leave for those reasons or quarantined or has been advised to quarantine. If they're caring for their own child, if the child's school or healthcare provider is, school provider is not available, or if they're experiencing any other substantially similar condition that Health and Human Services specifies. So there is a little bit of wriggle room later on, I think, as the COVID-19 crisis develops, that there will be potentially further health conditions that qualify, but right now it's just COVID-19. The hours of leave vary based on whether the employee is full or part-time. So full-time employees are entitled to up to 80 hours of pay, and that's based on 10 days of work on a 40-hour work week. They're entitled, part-time employees are entitled to the average number of hours that they worked over a 2-week period. It's based on their normal schedule. For employees who have worked variable schedules, they will look back to a 6-month average, or if the employee hasn't been with the employer for 6 months, just to remind you, this people who have been with the employer for 1 day qualify for this. It's based on the reasonable expectation of the employee at the time of hire, like what their hours were going to be. Can I get the next slide? Thanks. It also, the amount of paid leave varies as to the reason why you are on leave. If it's your own sickness or quarantine, then it's paid out at 100% of regular rate of pay, but there is a cap at $511 a day, or $5,100 in the aggregate for all 80 hours. And then employees who are caring for another qualified person are entitled to 2/3 of their pay. And that is also capped at $200 a day and $2,000 in the aggregate. Next slide. There are provisions for multi-employer bargaining agreements as to how those the sick pay will be allocated to each employer. Next slide. And then there's some miscellaneous provisions. The employers may not require that employees use any other paid leave provided by the employers before using the COVID-19 sick pay. So a lot of the questions that we've gotten are based on sort of the patchwork of unemployment of sick pay laws throughout states and municipalities that potentially require an employer in any case to provide sick pay. The Department of Labor, as of today, or as of last night, has not addressed that issue as to whether or not other mandated leave or leave in greater amounts than the sick leave provided under the Act, whether somebody can substitute that. The employee themselves can choose to substitute other amounts of time, but a discussion that we've been having with a lot of employers is, can I amend my existing PTO policy? And it's highly dependent on what your policy says and how the hours are accrued. So we're recommending that you consult with an attorney that can see the specifics of your particular policy. You also, as an employer, can't require an employee to find a substitute for them, for themselves, in order to take the sick leave. It doesn't roll over from year to year. It ends December 31st, and you have to post a notice of rights. And the one other thing I wanted to mention, there are penalties under the FLSA for not paying this out if you're required to. The Department of Labor, as well as, Department of Labor has said that there's a 30-day non-enforcement period where their goal during that time is to be providing guidance to employers, not enforcing, as long as there is a good faith effort to comply with the sick leave provisions. So there should be a little bit of wriggle room there. Oh, thanks. No, I'm done. And so the mechanism for covering these payments to employees for sick leave and for FMLA leave, so the two types of COVID-19 paid leave, are through separate tax credits on payroll. And employers can start taking those immediately, so it's an immediate relief. Of the two types that apply to employers, there's also some provisions for self-employed individuals that I'm not going to address right now, but they function similarly. You've got the paid leave for $200 for the care of others, and the 10 days, 80-hour per employee cap, and FMLA leave 200 per day. Next slide. And so the way those function is to be creditable against payroll taxes that the employer would otherwise take. Public employers, although they are subject to the paid leave provisions, they are not eligible for either tax credit. All payments that are made are exempt from Social Security and Medicare withholdings by both the employee and the employer. There are also some provisions regarding qualified health plans that you can offset those expenses and take to that plan and take either credit. And the Treasury is likely also, like the DOL, I think, likely to take significant latitude in interpreting and applying this rule. Next slide. They've released guidance, very initial guidance as to what this is going to look like and to describe the mechanism of how employers will be able to take this credit. And it functions to offset mandatory payroll contributions, including the employer's side of Social Security and Medicare, the employee's side of Social Security and Medicare, and then the employee's federal tax withholdings. To the extent that your payroll is, during this time for sick leave and FMLA leave, is greater than those credits would be, the credits are refundable and you can request those immediately. And in terms of fleshing out these numbers a little bit, because a lot of employers have looked at the $511 tax cap and had a little sticker shock about that, but it's based on 2019 Social Security wage base of $132,900 salary. So likely much of your workforce may not hit that cap. And then, you know, the amounts of Social Security and Medicare, how much of your payroll, typically withholdings are 10 to 40%. That you would be able to get back. And so employers, if they have less than a third of their workforce out on one time getting paid leave, would likely have normal liquidity, and it would only be above and beyond that number that you would need to request accelerated payments. And then in terms of cleanup for this, you would just on your quarterly payroll tax reports in July 31st would clean up on a form 941. So that is all of, no, thanks, thank you. That concludes the tax and paid leave portion of it. Thanks.
Great job. Thanks a lot, Susan. We appreciate the information. We are now going to turn the time over to Christina Jepson, who's going to touch on the final segment of our presentation today concerning the WARN Act. Christina?
Yes, I'm really going to be talking about the WARN Act and any other considerations you should keep in mind if you are thinking about doing any sort of termination, furlough, reduction in force. So in the 25 years that I've practiced employment law, normally in normal times, when someone's talking about a large RIF, we immediately ask, how many employees do you have? How many people are going to be affected, to try to figure out if the WARN Act or other acts might apply. Obviously, times are a little bit different now, and we've got to think about a lot of things. But in terms of the WARN Act, if you're not familiar with it, this is an act that was passed in the 80s to really require that employers, if they're going to have pretty significant reduction in force, that they provide 60 days advance notice to the employees who are going to be affected, so the employees can make plans, the local government can make plans, so there can be some efforts made to help get those people reemployed. So the WARN Act typically applies to large companies, to large reductions, which we'll talk in a moment about what those mean. And there are some exceptions that normally we don't talk about much because they don't apply very often, but right now, many of these may apply. Now, in terms of this only applying to large employers, what we're talking about with the WARN Act is it applies if you have 100 or more full-time employees, and these are employees who work an average of 20 or more hours per week. So maybe a little bit different definition of full-time than you normally have. Or if you have 100 or more employees, including part-time employees who, in aggregate work at least 4,000 hours per week. So those are the definitions. If you hit one of those targets, then you're considered a large employer and the WARN Act may apply to you. Now, as you can see, counting employees can be a little bit tricky. There's a lot of different things that come into play. So if you're close on some of those numbers, you probably want to talk to counsel about exactly how that applies to you. So yeah, the first question is, are you a large employer? If you're a large employer, then the second question becomes, is the reduction going to be large enough? And there are really two types of reductions that we're looking at. First of all is a plant closing, and don't let the term plant be confusing. It really is talking about any kind of business closing, or a mass layoff. Now, a plant closing is any sort of permanent or temporary shutdown in which at least 50 employees experience an employment loss. And we're going to talk about in a minute what an employment loss. But a permanent or temporary shutdown, it could be, of course, your entire business shutting down, but it also could be just a single employment site. It could be an operating unit. So if a whole unit closes down, maybe you manufacture multiple types of products, but one entire line is shut down. That could potentially be considered a plant closing, or if an entire facility closes down. Now, on the other hand, a mass layoff can also trigger the WARN Act, and a mass layoff is any reduction in force that where either at least 500 employees at a single job site experience an employment loss, or as low as 50 employees experience an employment loss if they make up 1/3 of the employer's workforce. So really you're trying to look at, if you have 50 employees who are going to experience a job loss, you got to think the WARN Act may apply. If it's less than 50 employees, you don't need to be concerned. So what is an employment loss? This is a really important question, especially during these times. Of course, it can be a termination. If you terminate employees, other than cause, or if they retire, that certainly would be a job loss. If there's a layoff, meaning you don't terminate them, people use different terms, layoff, furlough. If that exceeds 6 consecutive months, then that would count as an employment loss under WARN. So you have to kind of keep track. Obviously, when you start a furlough or layoff, you don't always know how long that's going to last. Another thing that can trigger the WARN Act is a reduction in hours of more than 50% during a 6-month period. And the WARN Act, even though it says it's looking at a 30-day period if these employment losses occur during a 30-day period. It's really more than that, because what they don't want employers to do is kind of do trickle layoffs or trickle terminations that, over time to try to avoid the act. So the WARN Act does have a 90-day look back and look forward provision so that, smaller layoffs, smaller terminations, if they eventually equal those large numbers, could potentially trigger WARN. Again, this is a tricky area, so if you're not sure, you make sure you consult with counsel about that. So what do you have to do if the WARN Act is triggered? Like I mentioned at the beginning, the main thing is that you have to give written notice 60 days in advance to the employees who are going to be affected. And there's certain legal things that have to be in that notice. And on this slide, there's a list of people who have to get the notice. And obviously this was written for more normal times, but it's things like union representatives, the employees, local officials, so that they know that there's going to be this big layoff and they can help out. If an employer violates WARN and does not give that 60-day notice, they can be liable to all the employees affected for all of their back pay during that 60-day period, their benefits, and their attorney's fees. So it can be a pretty significant penalty. And there's also a civil penalty that's implemented by government. Now, one argument that is really being considered right now is, what if you're shut down, which a lot of businesses are being shut down. If you're in a jurisdiction where there's been a mandatory government shutdown. So for example, right now, Summit County, they have a stay-at-home order. If that happens and you as an employer have no choice and no ability to give the 60-day notice, then there's, I think, a very good argument, obviously, that the WARN Act probably does not apply. But you should give as much notice as possible. One thing we're really telling our clients right now is to update employee contact information. These stay-at-home orders are going to spread. There are going to be more jurisdictions impacted by that, including probably more of Utah. So this is the time right now to make sure you have good email contact for your employees, cell phone numbers, some way to give people notice as quickly as possible if one of these orders goes into place. Now, there are three explicit exceptions that apply under the WARN Act, and two of which might certainly be applicable right now. So there's the faltering company exception, unforeseeable business circumstances, and natural disaster. You can see how the final two really might apply to a lot of businesses right now. All of us are being impacted by unforeseeable business circumstances, and there's an argument that this may be a natural disaster. So the unforeseeable business exception, this won't apply to you if you were already planning a shutdown, or if your shutdown or reduction in force has to do with something other than what's going on with COVID-19. But if those are the sort of things that are impacting you, it wasn't foreseeable, this is something you had, it's sudden, dramatic, unexpected, then you're probably going to be able to make a good argument that the Act does not apply. Again, just give your employees as much notice as you can. And if you're going to be relying on the unforeseeable business circumstance, you have to be able to make a case that you really are impacted by something that was unforeseeable. You're going to have to be able to show something like, the economic downturn really has shut your business down, or the government closed you, or maybe you have a contract that just your business partner has disappeared now and can't buy the product that you're expecting them to buy. So you're going to have to be able to put together a case, show that the exception applies to you. It's a good time to talk to counsel about this, because anytime you're making these decisions and you involve a lawyer, that can be attorney-client privileged and information that you wouldn't have to disclose if there's a lawsuit about this. Also keep in mind that if you have a layoff or a RIF, and initially it's less than 6 months, but because of the COVID-19 pandemic, it ends up going beyond the 6 months, it could be that you have an argument for exceptional business circumstances in that instance. Now, there's also, like I mentioned, a natural disaster exception. This is not something that I have ever even used in my 25 years of practicing employment law. It normally is things like earthquakes, which we've also been experiencing in Utah recently, floods, storms, that sort of thing. It doesn't explicitly mention pandemics, but obviously there's a good argument that that's a similar effective nature, and this may apply. Again, giving as much notice as possible is important. Now, even if the Federal WARN Act does not apply to you, it's important that you look to see if there's a state law that applies to you, because some states have their own laws. Sometimes they're called mini WARN Acts, but they could be called something different, where they have their own requirements. For example, in California, these sort of requirements for giving notice to employees kick in if you have 75 employees instead of 100. And sometimes it's a shorter layoff or a smaller layoff that triggers some of these requirements. So check your local law. Utah does not have anything like this, at least so far. But you know, obviously in these times, we literally need to check every day to see if there's something new passed. Even if the WARN Act does not apply to you, make sure that if you're doing any sort of layoff, that you're documenting the process, you have objective criteria, you're minimizing the risk that there's going to be a lawsuit against you that you laid off, you know, one group of people, that this heavily impacted people over 40 or heavily impacted women or a particular racial group. All those sort of factors still come into play. And also, if you've had any employees who've brought claims before, have you know, exercised protected rights, have been on health leave, ADA leave, FMLA leave, you know, those are riskier terminations, and you probably want to consult with counsel before including them in a RIF. Also, if you're going to do some kind of RIF, you need to make sure you look at your employment agreements and see if any of the people impacted have any particular rights, like guaranteed employment, guaranteed severance rights. Look at collective bargaining agreements if you have those. And make sure that as you lay people off, that you give them the pay they're entitled to, the severance they're entitled to, you pay them within the time period that you're required to under law, and that you give them COBRA notices. Also, you know, people are really thinking about, are there things that we should be doing to help our employees outside of what we're required to do? So counseling, having informational meetings, giving them information about unemployment, all of these things can be really helpful to employees right now. That's all I have. Thank you.
Great, Christina. Thank you very much for all of that very insightful information. As we noted at the beginning of the webinar today, we wanted to leave a little bit of time for Q&A. I recognize that we're bumping up against 1 hour. Why don't we do this for those of you that wish to stick with us? Why don't we take 3 questions? And Mark, I'm going to give you the thankless job of trying to identify which 3 questions that we can address to the group before we conclude. Mark, are you with us?
I am. I was just struggling to get my cursor over to the unmute button, so which people tend to want to press when I talk anyway. But anyway, so a lot of questions. We've tried to answer some of them in the chat. There's a question about, I think there were a couple questions about whether or not an employee, if an employee has already received 12 weeks of FMLA benefits or some number of weeks of FMLA benefits, does this statute, the Families First Coronavirus Response Act, does that entitle them to an additional 12 weeks? The quick answer to that is no. The statute just provides for the coronavirus related reasons specified as being an additional trigger, additional qualifying reason for taking the existing 12 weeks of leave provided under the FMLA. There was a question also about how the same kind of COVID-19 related family leave, how that relates to essential infrastructure employees or employers. And to the extent the statute provides an opportunity for healthcare providers or employers of healthcare providers and employers of emergency responders to exempt or exclude them from the various paid leave provisions. So it does address it in that response. Let's see, check here through, I think, would any increase in paid time off be counted in some way? I think the question is, will that be subject to payroll taxes? Ross, could you remind me what the answer is to that one?
So Mark, yeah, your question as to whether the FMLA paid leave and the paid sick time leave, if you also have to make payroll withholdings or tax application to that, the answer appears to be no.
And that's for the tax credits?
Yes, the tax credits. I think Susan largely detailed this portion of the presentation, so I'll let her, if she has anything else to say, respond. But yeah, that you don't have to then take a withholding there too.
I think that's my 3 questions. I know we didn't get to all of them, for which I apologize, but I think we're past the limit. Jason, could you also quickly address to how people can get copies of the slide deck or the recordings?
Absolutely. So thank you, Mark, again, and thanks to Sean, Susan, Ross, and Christina for all the time and effort that they put into staying on top of these issues and for presenting today. As noted at the beginning of today's webinar, the slide deck will be distributed to all attendees by email. If we did not get to your questions, please feel free to contact any one of the presenters or me. I will be sending out the slide deck, and we'd be happy to try and get to your question and get you the answer that you need. On behalf of World Trade Center Utah and Parsons, Behle, and Latimer, I want to extend another thanks to all of you for joining us for today's webinar. It will be, the recorded version will also be put on the World Trade Center Utah website along with their YouTube channel. Parsons, Behle, and Latimer at www.parsonsbehle.com. We will also be posting a recording of this along with the slide presentation today. So there are a variety of ways in which you can get this information. But in short, once again, thanks again for participating and joining us today. And we wish you, your families, and your colleagues all the very best during this very difficult time. Thank you very much.
Thank you.
Thank you.